Good morning, friends. Let us talk about 35th case law of advocate on record examination. So, be settled. I am going to start. This is case of Shayara Bano versus Union of India and others of 2017. This is landmark judgment regarding declaration of practice of instant triple talaq-e-biddat, unconstitutional. So this case is a turning point for gender justice and rights of Muslim women in India, addressing the conflict between personal laws and constitutional rights. Let us first analyze the background of the case, then we will dive further into the details of judgment. Background is Shayara Bano, a Muslim woman who was married to Rizwan Ahmed, and this marriage lasted for 15 years. In 2016, her husband divorced her through instant triple talaq, a practice that allows a Muslim man to dissolve the marriage unilaterally and instantaneously by pronouncing talaq 3 times. Shayara Bano challenged this practice, arguing that it violated her fundamental rights under the Constitution of India, specifically Article 14, Article 15, Article 21, and Article 25. Now, going deep into what is the meaning of triple talaq. It is also known as talaq-e-biddat. This is a practice under Muslim personal law that has been controversial because it allows men to end a marriage unilaterally and without due process of law. Muslim personal laws in India are governed by Muslim Personal Law Shariat Application Act 1937 and had historically been shielded from judicial scrutiny. Shayara Bano argued that triple talaq violated her fundamental rights and was not an essential practice of Islam, so it is not protected. The case brought into question the extent to which personal law could be subjected to constitutional principles. So now let us dive into legal issues before the Honorable Supreme Court. First one was, does the practice of instant triple talaq violated the fundamental rights granted under the Constitution? Second issue was, is triple talaq an essential practice of Islam protected under Article 25? Article 25 gives freedom of religion. Is it protected under that? This was the issue. And third issue was, can personal laws derived from religious texts be subjected to constitutional principles of equality and justice? So a bench was constituted, 5-judge bench was there, and this judgment is 3-2. This is split judgment by 3-2. Majority opinion. Firstly, I am going to majority opinion. The practice of instant triple talaq was declared unconstitutional by a majority of 3 judges, each providing different reasoning. 3 judges, majority view, having majority were no doubt concurrent that this is unconstitutional. But the grounds, they were differing. Now, Justice Rohinton Nariman and Justice Juju Lalit, they held that triple talaq violated Article 14, equality before the law, and was manifestly arbitrary, and argued that any practice that allows one party, her husband, to end a marriage unilaterally and irreversibly without due process is inherently unequal. No third justice were Justice Kuria Joseph. No doubt he concurred with the majority, but on different grounds. Held that triple talaq was not an essential practice of Islam and therefore did not enjoy protection under Article 25. Now, coming to minority opinion, Honorable Chief Justice of India of at that time, Justice J.S. Keher and Justice Abdul Najir, they held that the triple talaq was an essential practice of Islam and is protected under Article 25. However, they called for a 6-month moratorium on the practice to allow Parliament to enact legislation addressing the issue. And there was universal agreement on gender justice. All the judges of the bench agreed that gender justice and equality are paramount, and the practice of triple talaq was discriminatory against Muslim women. So let us explore judgment. By a 3-2 majority, Honorable Supreme Court declared the practice of instant triple talaq unconstitutional and invalid. The court emphasized that practice was arbitrary, not protected as an essential practice of Islam, and violated the constitutional rights of women, Muslim women. Call for legislative action. The court argued Parliament to enact a law governing the dissolution of Muslim marriages to replace the invalidated practice. Now, after effects of the judgment, in response to judgment, Parliament passed the law that is known under the title Muslim Women Protection of Rights on Marriage Act 2019. I am repeating, the Muslim Women Protection of Rights on Marriage Act 2019. This act criminalized the practice of instant triple talaq and prescribed a punishment of up to 3 years in prison for offenses. The case became a milestone for gender justice, empowering Muslim women and reinforcing constitutional principles over personal laws. The criminalization of triple talaq sparked debate about whether such an approach was appropriate or punitive. So, the judgment, the significance, if we go to that, the judgment reaffirmed the primacy of fundamental rights over personal laws in case of conflict. The case highlighted the judiciary's role in addressing regressive practices and advancing social justice. The judgment paved the way for future challenges to personal laws that discriminate on the basis of gender or other constitutional principles. Now, when there is judgment, there is democracy. The critics can also have say in this. So, critics argued that minority opinion overly lied on religious freedom aspect without adequately addressing gender discrimination. The subsequent criminalization of triple talaq raised concerns about whether a civil wrong was being unnecessarily criminalized. So, friends, now let us come to the conclusion of this case law. I have gone in deep into all the aspects. So, nutshell, the judgment, that is Shayara Bano versus Union of India, no doubt is a landmark decision in Indian constitutional law, striking down the regressive practice of instant triple talaq. It also strengthened the constitutional principles of equality, dignity, and gender justice while reinforcing the judiciary's commitment to protecting fundamental rights against discriminatory practices. So, this is all about today's case law. I feel you might be enjoying my videos. If you feel there should be some improvement, feel free to call me. I am making my videos in simple ways, not you can say not editing or giving it a look, rather than I am focusing on my material, not on look. So bear with me. God bless you all.